initiate chaos theory guarantees that we'll play like lightning shots sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only waits us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All aboard the Petty Express. Misdirected from the start. It's a runaway train. I come a freight train. I come a freight train. In a beautiful darkness, the Petty Express. In a beautiful darkness.
So, Falanos, I am not quite sure. It seems like they ran out of witnesses. We've got one more witness after Rain Man, and then it seems like the defense thought this was going to take longer. Yes. So, yeah, I don't know, but it looks like the judge sent the jury home and we are going to get started on jury instructions and charging documents. But first, the mood I felt like coming back with. Again, Major Payne, dear Lord, please come to this courtroom and tell Kim K to be quiet.
It's allowed on these here premises, Mr. Ace Ventura.
He's my blind seeing eye dog.
What in the world would anybody want with a blind dog?
The dog ain't blind. I'm the one that's blind, you idiot.
Oh, I see you and your friend Cujo here got a little attitudinal problem.
Okay, so this is where my Moism started because I fell in love with the word attitudinal. I don't know why, but I was like, oh my God, people can make up their own words. The rest was history. But we can, tribute, credit Major Payne for being the one that started Moisms.
Need some readjusting. Hey, Cobra! Go tell Mom bring my field knife.
Dear Lord, make Major Payne 2. Hollywood, you have basically, made sequels to all movies that I actually used to love, and you destroyed them. Actually, don't make Major Payne 2. Stay away from Major Payne. All right, let's get back to Rain Man.
In all honesty, I was a little bit surprised.
Sir, that's the answer to the question. It's either yes or no. Somebody else could have taken it over?
Yes.
Okay. I'm going to strike the part after the word yes. It could have been somebody else.
And to your knowledge, over the course of the, let's say, starting in the 2000s, from 2000 up until 2018, like those 18 years.
Oh, wait, we got past this. Yeah, okay, so we are going to start with this. I do not know who this is, but probably another friend of Paul's.
Ma'am, just watch your step. If there's a step up to the witness box, if you don't mind, please. Thank you. If you don't mind, before you sit down, could you put your left hand on the Bible, raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, once you're comfortable and seated, can you state your full name for the record and spell your last name, please?
Sure. My name is Stacy Pritchett. It's Pritchett.
Ma'am, I'm just going to ask you to speak up so jurors number 15 and 16 can hear you, okay?
Of course, yes.
All right, thank you so much. Ms. Massalone, when you're ready.
Thank you. Good morning, Ms. Pritchett.
Good morning.
Can you please introduce yourself to the jury?
Hi, my name is Stacy Pritchett. Shall I spell it again?
No, you're good.
What's your current occupation?
I work in marketing.
And
Hey, Kim K and Giggle Pants, you are aware that you're here. I know you're on the side of the defense, but do be aware that this is actually a quadruple homicide. And we just heard like really shitty testimony yesterday. So maybe being, super jovial is the wrong tonal, uh, you know, pitch, maybe.
What's your educational background?
I have a BA in literature from SUNY Binghamton and an MBA in marketing from Brewer College.
And are you married to Jim Pritchett, who we just heard from?
Yes, I am.
So obviously we just heard from your husband, so we already have some background. But can you just explain a little bit to the jury about how you met Susan and then Paul?
Absolutely. I met Susan when I was a sophomore in high school, so about 43 years ago. We went to high school together, we had a lot of classes, and we just became friends. We did a project together, and we just really hit it off. We were very close in high school. I went away to college, and I would write letters, and we kept in touch. And then after college, when I moved back home, we rekindled our friendship, and I would consider her my best friend, more like a sister, and Paul more like my brother-in-law. I've known him about 42 years, and I consider them.
I have no idea. Also, I get it. You believe that Paul is a great guy, but you do realize he's accused of killing family members. Why is everyone on the defense saying that they feel like family? That should be the unsafest that anyone has felt since, I don't know, marrying Amber Heard.
Like family, I consider Katie and Marissa like my nieces, and my kids introduce them as their cousins.
Okay, so just to back up for a moment, you mentioned you met Susan in high school,
I did,
right?
yes.
And you were around how old at that time?
I was about 15 years old when I met Sue.
And what about when you met Paul? How old were you then?
16 or 17, in that range. So about a year after I met Sue, I had met Paul.
So
They
still
had
in
started
high school?
dating, still in high school, yes.
And again, we heard from your husband, but can you just explain a little bit more about your relationship with the Caneiro family? I know you just explained that you consider them like family, but how did your relationship develop over the years with the families as far as like things you did together, and events, activities, and things of that nature?
We became like family. Sue, like I said, is more like my sister than my best friend, and Paul, my brother-in-law, the girls like my nieces. We went on family vacations. We went to Disney World. We went to Hershey Park like once a summer. We spent every Christmas Eve together. And during the summer, we were there like every other weekend. I used to joke that it was my shore house. But we spent a lot of time together as families.
And during the summer, we've heard a lot about these barbecues. Can
Yes.
you tell us a little bit about that?
So we would go.
Hey, defense. Not that I'm going to stop you while you're torching your argument, but do you think maybe in an arson case you shouldn't highlight that Paul's always liked to play with fire? I'm not telling you how to defensinate or anything, but maybe highlighting that Paul's always had a propensity to burn things when he's accused of double arson. I don't know.
Once they put in their pool, we were there regularly. We would go every other weekend. Paul is a fabulous cook. He would barbecue. He'd make the best steak that is still talked about in my house. And he would cook, and the kids would swim. We would all swim. They'd play on the trampoline. They'd play with each other, and we just hang out. We spent a lot of time with them this summer.
So based on how well you knew Paul, how would you describe him?
I would say that Paul is highly intelligent, loyal, very helpful, dependable, very logical, and very even-tempered.
And
Chickadee bucket. Mo, if you ever red rum me like that, I give you permission to tell everyone I was the younger and much dumber and very flammable brother. God. Yeah, let's make the defendant that you're trying to help. Let's make it sound like, he might have taken a little taste of one of the family members. He pulled a Chandler. He what is one taste between a leg of brother, a rack of mom? Jesus, Mary and Joseph, what is this defense? I feel like I should have taken a Quaalude before this. Oh my God. What in the name of... Oh, God.
Sorry, did you say he was?
He's very helpful. He was always helpful to me personally, to us as a family. He was always there if I needed advice. He helped us with when personal computers became a thing. It was Paul who set us up. He set up my computer. He set up my mother's.
Oh my God, Paul has just a repository of everyone else's porn. He set up back channels to, monitor. He has weird external hard drives. Changed my mind.
Computer. Whenever I had an IT question or a technical question, I would ask Paul. He really was my go-to person for anything technical. He advised me on what tires to buy. And then when Jim and I moved to New Jersey and we bought our house, things were broken and he came over with his drill. He fixed our cabinet. He fixed other things around the house. One time when my husband was traveling and my kids were very, very little, our boiler broke. And I called Sue and I spoke to Paul and he told me what to do. I called a repair person and then he stayed on the line with me the entire time that the repair person was there. So he was always very, very helpful.
And
Again, up until the point that he had 20 minutes to drive over to his brother's house and 16 minutes while he was dismantling the electric. He was a real helpful guy, and then he gutted 2 children. So, excuse me if I don't give a flippin' flapjack if he held your hand while your water broke and helped you with your Lamaze breathing. I could give 2 rats rah-rahs, okay? Really and truly. So, what is this defense?
as a result of how well you knew Susan and Paul and their family and how often you saw them, and you said like every other weekend,
Yes.
a lot during the summer, did you have the occasion to see Keith and Jennifer and their family?
Yes, we saw them every Christmas Eve because they would come every Christmas Eve and we'd all exchange gifts, and we'd see them a lot during the summer. So they wanted to swim in the pool and eat Paul's cooking and play.
What in the Kubrick smile in shining hell is this? First of all, Paul, no one is going to trust this woman when she looks like frickin' John Lithgow in a terrible wig. She looks like she should be telling us not to dance in Footloose. It's the weirdest damn thing I've ever seen. In fact, I mean, because she almost has the little stash like Lithgow. I can see her saying, "No daughter of mine will dance." Also, ma'am, again, I remind you kindly that this is kind of a fucking quadruple homicide. Could you possibly not be grinning like a sociopath? Clip that. Y'all, there is not enough therapy in the world for this shit, y'all. There's just...
and hang out. So we spent a lot.
There is no amount of $12 therapy putty for the TISM and the ADHD. Jesus, Mary and Joseph, what is this defense? Y'all, thank you for being here and helping my sanity, because I'm trying not to laugh because what is this?
A lot of time with Keith and Jen and the kids every summer, a lot of time.
And so based on what you were able to observe with the interactions with the family, can you tell us about Paul's relationship with Keith?
Yes. So in the 40 or so years approximate 40 years that I knew Keith.
Have you ever had eyebrows in those 40 years? Have you always looked like Trinity with a wig on in Dexter? And people let you around small children? You and Rain Man? Like, what in the world of rejects were the people that Paul attracted to him? You've got Mr. Speculum and Miss Speculum. You've got Rain Man, and then you've got John Lithgow. I am... Honestly, this is more entertaining than going to a Walmart. This is like a train wreck that I don't even have to turn on TLC for.
and Paul. I observed them often, and they had a very loving relationship. Paul loved Keith very much. He would call him his person, his best friend. He was always there for Keith. He was they were best friends and business partners, and he was very protective.
Again, until he shot him in the ass and 4 times in the face. Are all of y'all unaware of what happened to Keith's family? Jesus, whatever Kool-Aid y'all have been drinking, stay the hell away from it. Or at least tell me the flavor so I can stay the hell away from it.
Of Keith, and he loved him very, very much.
And did you ever have the opportunity to see them disagree or argue?
Yes, I mean, they were brothers, so of course they disagreed. Yes, they would disagree. They would discuss things, get their feelings out there. I actually admire their relationship because they could disagree.
Jesus Christ, this is so tone deaf. Defense, do you not understand that whatever slim chance of mercy Paul could... This is the one and only time that I will say that, that bumper sticker, Jesus loves you, everyone else thinks you're a cunt. I think that even this time Jesus is like, he doesn't go here. Like, I'd like to not be added into this conversation. Like, Paul's bumper sticker is even Jesus thinks you're a cunt. All right? So you having a cavalcade, a fucking parade of weird, shiny, happy people from REM. I thought your case was going to be bad defense. I never for the life of me, thought it was going to be worse than Battlefield Earth. Like, Battlefield Earth looks like a Shakespearean play compared to whatever this is.
And then go back to being best friends, going to lunch. So they would disagree. Usually it was Keith who would lose his temper. Paul was always the more even one, the fixer, keeping calm. And they would disagree, and then they would resolve it and move on and go out to lunch and just resume the relationship like nothing ever happened.
And what about Paul's relationship with Jesse and Sophia? What can you tell us about that?
I can tell.
I need to take a deep breath. Because whatever John Lithgow has to say with her shiny, happy people voice, what in the name of Prozac and SSRIs is this general personality? Is there like a nuclear facility near New Jersey? Is there an ancient Indian burial ground? Is there uranium or too much fluoride in the water? What in the genetic mental deficiency is going on here? It's like a cluster. I feel like we should get the WHO involved. I wish I was saying the band, but no, the people that claim they're, World Health Organizations. Look, I want these people to get help, but I'm not bothered with the quality, if I'm honest. So the WHO it is.
That he loved them very, very much. I would say that Jesse was the son he didn't have. He loved Jesse, he loved Sophia. He absolutely adored those kids. I know when Jesse was in preschool or kindergarten, he was allowed to bring an adult to school with him, and he chose his Uncle Paul. I mean, that was how much.
I am speechless. The defense called this witness voluntarily. I have never seen such absolute obliviousness to the temperature in the room, the general situation. Even if Paul is your friend and you defend him to the utmost, this if you had any self-awareness and you really wanted to protect Paul, you wouldn't be acting like this. This is almost as if everyone got together and they were like, we shall finish him ourselves. At this point, I feel like the state has planted these people. Like, what? Daryl Brooks did a better job, and I never thought I would actually say that.
Much Jesse loved Paul, and it was absolutely reciprocated. He absolutely loved Jesse. He absolutely loved Sophia. He loved those kids.
Focusing on the businesses for a moment. To your knowledge, again, just based on your experience knowing them and what your personal observations were, and getting to know Paul, getting to know Keith over the 40-something years, were you privy to when the businesses started and as they progressed and things of that nature?
I was privy to some of it, absolutely. I know Keith started the business and then he brought Paul on, and Paul was the one who really grew the business. He went out and he got clients. He was very instrumental in building the business. I know they worked very well together. They were very compatible. I think Keith was more strategic and Paul was more tactical, more hands-on. He was always there building the business, and they worked very, very well together.
Now,
again, ma'am, sir, Trinity, until he shot him in the ass and destroyed his entire family. I don't know what level of antidepressants you are on, but it is too much, ma'am.
obviously, again, a lot of time has passed since November of 2018. Are you still close with the Caneiro family?
Absolutely. They are our family, and they always will be.
Thank you.
Cross.
Thank you. Good morning.
My first question, are you a flat earther? How many SSRIs are you on? Have you had a cognitive neurological test in the last year? Have you ever been attracted to a cult or a multi-level marketing scheme? Do you believe the Inquirer or the government?
Good morning.
You said Keith would always lose his temper.
Not always. He was the first one to usually get agitated and start yelling.
Okay. Paul was very level-headed, right?
Yes.
Now, I assume you'll agree with me that you didn't hear Keith lose his temper on a phone call with Paul on November 19th.
No, I did not.
Never heard that, correct?
No, I did not.
You also said that Keith started the business, right?
Correct.
And you said that Paul then had a lot to do with growing the business, right?
Yes.
And I'm sure that's fair. But were you aware of the ownership structure of, when I say the business, let's say Square One, did you know who owned what?
I had an idea.
And what was the idea?
I think, mostly Keith's, and Paul was part of it as well. The majority was Keith's.
I have nothing further, Judge.
Anything else?
No, thank you.
You can step down, ma'am. Thank you.
Thank you.
Defense, call the next witness.
Judge, that's all we have for today.
Okay. All right. Ladies and gentlemen, you get to go home. So that'll end us.
Defense, if you don't think the jury is going to be mother effing pissed that they now have another weekend, that they have to keep this in their brain, that they can't talk to anyone after Wednesday, and you wasted the Friday that you could have been working on jury instructions or doing closing arguments to do whatever the hell this was? If you don't think that the jury's not going to remember this, because God knows I would, and punish you greatly for this ridiculous argument that you're trying to put forward. Because at the end of the day, your client instructed you. That is the main zeitgeist of this defense is, I was such a good person. This is this is straight from Paul. This is what happens when you don't have lawyers that are smart enough to either say, hey, this is going to go against my ethics because, I am willing to protect your constitutional, rights. I am willing to hold the state to their burden. I am willing to, if I see a strategy, to try to add reasonable doubt. But I am not willing to sell my soul for a stupid argument and look like a jackass in court. So I would have recused my position. I would have asked for a withdrawal from this case if this was the argument that Paul wanted me to make. It's called integrity. Defense attorneys often know that many of the times their client has done the evil thing that they are accused of, or the criminal thing. But that's not their job as a defense attorney. Their job as a defense attorney is to make sure that their rights are protected, that the state doesn't use its overwhelming power to, extremes, that they are held to their limits by law, and that he has a fair and reasonable trial. You could have done a good job. There are some things that I think that the state, at least until the last day of testimony, hadn't addressed. And I think you could have poked some holes in that. But this character witness, these smiling, happy people after the autopsy testimony that we had Wednesday, is just gobsmacking. I have never been more sure that Darrell Brooks could have provided a more competent, logical defense than these two supposed public defenders.
For today, we'll be back again here on Monday morning, first thing, just like we are. I'll have you here at 8 o'clock. We'll have you up by 8:30. We'll continue on. There's things that the attorneys and myself have to do outside of your presence, so we'll be doing that. So it's not like the case is not doing something during this time frame, but I'm going to send you guys home. So hope you have a great weekend. Hope it doesn't snow. And don't discuss this case and don't do any research. Thank you so much. Appreciate it.
Okay, we're supposed to be getting back to jury instructions. Or let me see here. Okay, so I'm looking at court TV. See, I know they did something. They ran out of witnesses for the day. They're running late. They are supposed to be coming back. They were supposed to be coming back at 2:30 for jury instructions and looking at charging documents. No, JKD Buck, they ran out of witnesses for today. Apparently, they assumed Cross was going to take so much longer with these stellar witnesses. I feel like asking if there's a lot of lead paint in New Jersey buildings, or exposure to uranium or something. Now, they are supposed to have more witnesses on Monday. If they continue on these character witnesses, I don't know. That being said, if you think that the jury appreciates having to go another weekend with all of this, especially after Wednesday, I have never seen a defense be so tonally off, so completely dismal at reading the room. And And I say that as someone who generally thinks that public defenders are some of the best lawyers because they're constantly MLS. So this case is the Caneiro case. And Paul, the defendant, was one of three brothers, the Caneiro brothers. Now, Paul was the oldest brother, and he was in business with Keith. Keith was about 1 year younger than Paul. Now, there are two businesses that they co-owned to different degrees. The more profitable by a great margin business was Square One, and Keith owned 90% of that, and Paul had 10% ownership of that business. They co-owned this EcoStar, which is kind of like a Terminex, 50-50. Now, around the time in 2018, November, Square One, the more profitable company, was going to lose its final client. And Keith was looking very diligently at going back to school and maybe working for someone else, but definitely achieving a higher level of education in computer systems to better support his family. And there have been allusions, but no concrete evidence that one of the motivating factors for Keith wanting to leave and kind of go be an employee for someone else is that Keith noticed that Paul was kind of fiddling with the finances to a degree. And he didn't want to have to be Paul's, call me every, Venmo me this, I need money for that. My life is so hard kind of thing. And he didn't want to be responsible for Paul anymore, basically. Now, Paul had a wife and two adult daughters, but he was living far beyond his means. He was on disability. Now, he also had disability insurance and things like that. So while he was making a good bit more than you would think someone strictly on disability would make, he had, I believe, 5 cars that he leased. He had a side piece who had one of the 5 cars, one of the 5 leased cars, and a condo payment, and was generally in a lot of debt. Now, the incident that sparked, this case was Keith finding out for the second time that Paul, who was the trustee of his whole life insurance trust, his irrevocable trust, had for the second time not been paying his life insurance premiums with the money that would go in the trust as the trustee. He was basically doctoring bank statements to have it look like the money he was stealing was going to Canada Life Insurance, but he wasn't paying this. Now, this had been the second time. The first time he had been caught embezzling from the trust was in April of that year. So he did pay that back, but in a sleight of hand, the money that he stole in April that he paid back, he immediately transferred back to his bank account after it showed up as, a deposit. So since Keith was not really the trustee or really couldn't have a whole lot of input in an irrevocable trust, he did not get bank statements that weren't doctored by Paul. So November 18th, Keith is going over things with the accountant because he's gotten a call from Canada Life Insurance that they haven't received a payment in almost 5 months. Yet again, he's being told by Paul he's getting these bank statements. He and the accountant are, looking at this and they're seeing, electronic deposits or transfers to Canada Life Insurance. So they're really confused as to what's happening. And Keith calls Paul and he says, okay, look, we've got the bank statements. Is something going on here? I need to check this. I've just spent, half the day talking to Canada Life and they have not received any money. So what is going on? Well, the first call was around 3 p.m. Then there's a call at 6 p.m. and Keith is now pretty pissed off. He realizes probably that Paul is stealing again from the trust. So he basically asks Paul for the login and his, ID to get into the banking information so he can look at the real bank statements. Now, Paul says, I have a migraine. I don't remember what my login ID is. Give me a minute, like an hour or so to lay down, and I will totally get back to you. I can't even function. Well, Keith waits until about 8 p.m. that night and sends him an ultimatum. Or 6 p.m., sorry. Either you call me by 8 and you have some kind of answer for me, or I'm going to figure out something. And if you've been lying to me, it was basically, we're done. We're done. Now, Paul claims that he, went to sleep. Actually, we don't know what Paul claims right now because the defense hasn't called him. But what the state has proven is that around 2 p.m. or 2 a.m. in the morning, Paul's inside security for the garage and the unfinished part of the basement went off. Now, unfortunately for Paul and Stealth, the wise security system takes a picture of the last thing it sees, and it saw Paul's balding head unplugging one of his security cameras. Then we basically have various views of Paul's Porsche Macan, I call it a pecan, not only leaving his neighborhood, but entering the neighborhood of his brother Keith. Not only that, we then have video evidence from Keith's garage of someone who looks very much like Paul with a full head of dark hair and an itty bitty bald spot right in front of this frosted glass garage door. Now, for 16 minutes, we see this figure go back and forth. And the state has proven that someone, again, Paul at this point, has, in fact, basically, Paul dismantled not only the electrical box from the electric company, but also the backup generator that should have gone on. Now, Keith had a fairly sophisticated security setup, so everything was recording until the instant at around 2:57 when the power went off and the backup generator failed to kick in. Now, Keith at around 3:15 text Paul. Now, Paul, coinkadinks, in a coincidence, left his cell phone charging at his house during this midnight trip. Wouldn't you know? I'm getting there. And darn it, just didn't get those emails. Well, Keith went out to check why, the house had suddenly gone out of power. And Paul was waiting out there and shot Keith, I believe it was 6 times. Once in the lower back near the butt, and then 4 to 5 times in the head. Paul then went into the house, took care of Jennifer, Keith's wife, by shooting her and also stabbing her. He then, Griffin, out. So then he decided to take out the children. Now, it was very, very important for Paul that all of the family members of Keith Caneiro pass away, because what Paul knew was that if everyone in Keith's family died, he was a contingent beneficiary with his brother to the tune of $1.5 million. Now, allegedly, Paul then cut the rest of the security apparatus, got the fiber optic cables also cut, and started a slow burning fire in a cedar lined closet in Keith's home. But basically, by cutting that fiber optic cable, he also dismantled the fire alarms and the smoke detectors. And Keith's house was built of, at least externally, of concrete. It was fairly modern. So even though this fire was going for hours and hours, no one was really aware of it because Keith's house was further from neighbors. There was foliage around it. So this fire actually smoldered until about noon. Now, oddly enough, Paul's car can be seen again by the neighbors' Ring doorbell cameras getting back to his house around 4 a.m. And then, coincidence of coincidences, wouldn't you know that a fire starts at Keith's or at Paul's house? Now, Paul's house had the benefit, well, in hindsight, Paul didn't calculate very well because he had unplugged his security cameras, but not his smoke detectors and fire alarms connected to his security system, meaning that though Paul had used gas to start a fire very near to the gas pipeline, the natural gas pipeline, it only had a few minutes to actually go. Now, there was still significant fire damage. And I just want you to keep in your head that Paul lit this fire in the basement window well directly under where his wife sleeps in the master bedroom. Paul and his wife slept in different rooms, I guess, as you would if your husband has a Colombian side piece that you pay for her rent and her Audi. I mean, I wouldn't sleep with him. So, you know, coincidence of coincidence. You have a wife, you have a side piece, and oh, you have an arson that might potentially, you know, make the gas main explode and take out your wife. Interesting. Well, Paul's plan kind of went a little sideways here. I guess he wasn't anticipating the amount of time it takes to have a fire involve a gas line or how quickly the first responders would actually show up to his house, because the fire was contained and they were able to, yeah, he set his own house on fire. Basically on camera, because he might have, dismantled both himself or his and his brother's Ring doorbell cameras. But what he failed to take to account was everyone else's Ring doorbell cameras, which kind of makes the defenses, at least one of the three-prong defense, my client is not a moron, a little hard to justify when you hear the following things that he left behind. Well, when the first responders got the fire taken care of, they found a melted gas can that matched a dust spot from Paul's own shed near the garage. And wouldn't you know it, of all the cars in the driveway, the Porsche Macan was the only one that was attempted to set on fire. And it was the only car where a cadaver dog actually signaled on both the seat and a pair of gloves, nitrile gloves that were found in that car. Now, the biggest boon for the state has to be that they were able to quickly get the fire under control at Paul's house, because in the basement, they found not only a bunch of debris, they found this pile of debris that the cadaver dog kept signaling to. And it included in this pile were a pair of jeans, a shirt, a sweatshirt, a scarf from Brooks Brothers, an Eddie Bauer shirt and, regular or, designer brand Levi jeans that just happened to have the blood of Paul's nieces and nephew on it. Not to mention the inside of the gloves had blood matching the niece and nephew from various stab wounds. Now, the police find all this, the melted gas can, and decide to ask the Caneiro family, who happen to have enough time to get away from the fire in their home, to back out a Porsche Cayenne with a go bag in it that happened to have a barrel that ballistically matched the bullets found at his brother's house. It gets even better. Now, the defense's argument against all of this evidence is three-pronged, and it goes like this. My client isn't an idiot, and he would not leave all this evidence lying around. 2, the police had blinders on. They only focused on my client. And 3, the bald-shaved third brother, who in no way looks like the man captured fiddling with the electronics panel, done it. I cannot. I have been making sure I haven't been having TVAs. I've been making sure that both of my arms are moving. I need to clip the recap so I can give people a little, but that's basically the story in a nutshell. Now, to further underline the absolute stupidity of this defense, Wednesday, we had to listen to 4 autopsy reports of Keith, the brother, of the wife Jennifer, and then of the 2 children. Now, we had 2 medical examiners cry. And the last one was a very stoic, very professional Chinese doctor who kept it together until the very, very end, when he had to talk about a little 8-year-old and talk about how even though Paul stabbed her, to where they had to make the autopsy easier for the jury, they had to group these stab wounds in 16 different groups. And they've decided to bring what I can only describe as the most ridiculous cavalcade of shiny, happy people in the true REM sense, shiny, happy people holding hands, that have talked about Paul again, because we had a day off yesterday, and then the defense thought it would be a great idea to bring in a bunch of character witnesses that talk about Paul being a good uncle. I have never seen, even Daryl Brooks could understand that he should probably cry, during parts of his, whatever that defense was. I keep waiting for Ashton Kutcher to come out. It's like both of these lawyers went to the Zoolander school of, law for kids that don't read good.
We're back on the record with State of New Jersey versus Paul Caneiro, indictment 19-02-0283. We have all the attorneys present. We also have the defendant present. I had asked the attorneys to go through the exhibit list for both the state and for the defense to at least be in a position so that you tell the court what objections there are. We will argue those objections now. And then what we'll do is, after the defense rests, whenever that may be, at that point in time, I will formally move in the evidence. So it can be considered by the jury. So let's start from the beginning. At the top, from the prosecutor's office. I'm not sure who's going to be handling this, but let's start with the photo book. Tell me where we are. Tell me the ones that we are moving without objection, and if we're not moving them, the process that you're going to go about so that the record is clear. I see Ms. Wallace standing up. So the process of what you're going.
That's all the witnesses that they had lined up for today. I don't know in what world they thought that these 4 witnesses. So you had Dr. Speculum, Mrs. Speculum, well, that kills my imagination about swingers. Then we had Rain Man, the friend, and then chick who looked like Trinity from Dexter with a bad wig. It really was a stellar first day for the defense. Really, a monument to de-evolution.
To how you're going to go about blocking out pictures that you did not use so that we don't have any issues in front of the jury.
Thank you, Judge. We'll be moving S1, A through I. However, there are several pictures that we did not use that we would black out that I have listed.
Okay. I mean, have you gone through with the defense? Are both of you in agreement as to which photos are in and which photos are going to be blacked out?
I don't know that we went through those. I'm sorry.
What have we been doing?
So Judge, if I could, before we broke for lunch, my understanding is.
Okay, no, Judge, seriously, you want the state to have to, doodle in crayon for these idiot morons? What's going, no, I didn't cut my hair. It just, the longer part's in back. So if it kind of goes behind my shoulder, it looks like it's a shorter bob. No, there is not enough crayons. There is not enough paper, and there are not enough Blue's Clues to explain this case to the defense. I'm not going to punish the state for not wanting to explain things to a bunch of window lickers.
That the court wanted the parties to organize their evidence and decide what each party wanted to move into evidence. So that's how the
Judge, here is my case in point. No one should have to deal with the stupidity that is being witnessed here. I thought that we were going to look at it later because Spain could be anywhere.
Defense spent the lunch break. We went through all of our photos. We organized them so they'd be in order for the court and for the state to review so that they would be organized. We looked at our documented exhibits that we had. We decided, yes, we want things in or what have you. So that took the hour and a half or however long we had during the
It is called an hour and a half. Time is real, not a social construct. Again, this is the reason that every time a woman is in a position, people automatically assume that standards were lowered to allow her to get that position. This is case in point. This is exhibit A, if you will, on why people assume women got their jobs because standards were lowered.
Lunch break. Then when we came to court at 1:30, we were under the impression that at that time you wanted us to confer. So we had a copy of the state's updated exhibit list, but we didn't have access to their exhibits. So we weren't, it was kind of out of context, like an email dated. We needed to actually be able to compare from the item in the exhibit list to what the item actually is as far as.
Do you have the comprehensive skills? Because hitherto this point, you have not shown the ability to extrapolate information from basic context clues. So I do understand that you need but you have not shown the ability to be able to extrapolate logical conclusions from anything.
Whether or not we had an objection. So we just spent the last hour and a half once the court gave us access to those exhibits, we were able to categorize these items as far as either no objection or we do have an objection or we're reserving because we're just not sure. I think some of this has to maybe even be researched as to whether or not it's admissible. So that's where we are. We can let the court know certainly what things on their exhibit list we do not have objections to, or that we do have objections to, or that we are uncertain of at this time, but we can certainly let the court know, next week.
Okay, I should be back. Let me make sure I'm on the right mic. Yep. No. All right. I should be back and on the right mic now.
Also, we did not have opportunity to look at the photo and see. I mean, I can represent that generally speaking, we don't have an objection, but perhaps once the state has the opportunity to black out the photos and has like the final photo book that they're gonna present to the jury, we can just flip through it and let the court know if there's one or two photos that we have an objection to.
All right. So I'm not sure how the miscommunication happened because I had indicated that I wanted you guys not only look through your stuff, but also to discuss what objections that there would be. That's fine. We're here and we are where we are.
This judge. You know, it's bad when he goes to disappointed father. Like, I'm not even mad anymore. I just want you to explain how you came from my lineage. What was I near like a Fukushima? What happened specifically to you? How did this happen? And he means you.
So obviously, let me just say this. The items that have been testified to, that have been on that screen, there was no objection for those items to be placed on the screen. So I would have difficulty, so the defense is aware, to not allow in photographs that the jurors have already seen. Foundations have been laid. Any photo that has not been shown is automatically out. So that's not even going to be an issue. And the way that I would suggest doing that is, how many are we going to do on a page for purposes of the jury book for the jurors?
For the jurors, it's going to be one per page.
So one per page. So if you're going to do that, then my suggestion would be is that you can just do them in chronological order. Just take out the ones that were never shown to anyone. I have my book also. I tried to write down that like everyone has here, which I thought was great. Good job. But I did the exact same thing to make sure that I have my own notes as to what picture was showed to whom.
Now, I really do like this judge. I very much like his incorporation of technology, the touch screen that annotates what the witness is indicating, and then taking a screen capture of that for the record. I find that very helpful. Now, I do believe that those will be able to go back to the jury should they want them, because they were entered kind of as sub-exhibits. So it's actually, I have just been very impressed with the amount of exhibits, the amount of evidence that was brought in. He has really been very careful to notate, annotate it, and to clearly identify each piece, and to ask clarifying questions if he didn't catch something. So I've been impressed.
So I'll have that. So once you have that book, if you want to, over the weekend, I want you guys to talk over the weekend and look at the photo book, show it to each other. If there's any issues, that Monday when you come back, that we don't have to spend time, that it's just for you to take a look at it. And at that point in time, let me know if some picture you're saying was not shown to a particular witness, so you would have an objection to it, or if every picture was shown, you're going to have to prove to me why that now, after it's already been published, it's already been shown by a witness and its foundations have been laid, that I wouldn't allow that to be in. So I say that to you just as a background.
Because the defense only called 4 witnesses, and I think it's still up in the air whether Paul will testify. Considering how poorly they've read the room, I think Paul's going to testify. This is the most train wreck trial I have ever seen, and I have watched plenty. Even Bradley Yawn argued better at some points. And that's terrifying.
So, for purposes of pictures, I'm only talking about right now, that's it. That would be the court's request. That's going to be my ask of you. So you guys could take that advisement and instruction, and we'll talk about that on Monday. I won't touch the book for now. I recognize there's a lot of pictures, but a lot of this stuff I think should be pretty straightforward once you've had the opportunity to look at it. All right, so let's put that aside as the S1. Okay. What's your next item that you're attempting to move?
S2, Judge.
Okay. Is there any objection to that? I was shown today. Okay. So that will be in evidence. Next.
S7.
No objection.
Okay. Because we need photographic evidence, and at this point we're not going to watch the whole thing, so let me get... This is why we call him Judge Kent.
Wake up, Kent.
Ow!
Kent,
What?
I'm talking to you, Kent.
What is this?
I said I'm talking to you.
No.
Yeah.
Well, not asleep.
I'm trying to see if this clip... Okay, here. You can see... if I have a broom in here, you would be able to see it. If you don't see it, it's not in here. Look, this is what made Judge Kent become a judge instead of stay in engineering and physics.
All right. Who is this?
Cut the crap, Kent. You've built a weapon.
What?
What do you think
A secret phase conjugate.
tracking system is for? A big mirror makes a big beam.
I guess it could be.
Where's the laser now?
And see, now he has to deal with this defense. I feel bad for him. Maybe you should have stayed in physics.
Next.
S8.
No objection.
Okay.
No objection.
Okay.
S11.
No objection.
Okay.
S12.
No objection.
Okay.
S12 included some sub numbers.
Yeah, 1.1.2.3, people marking it up. Any objections to the marked up photos, Ms. Mastellone?
I don't believe so, Judge.
You should have copies of those. I'm assuming Anna gave everyone, you have it? Okay, good. So for the record purposes, when I accept these, it would be not just S12, but S12.1, .2, .3, .4, and .5 will all be in. Okay, next. 17, I'm sorry? Okay, yeah.
No objection.
All right.
S18, no objection. S19, A.
It looks like Tristan Ponytail Esquire III has an objection. Let's hear what the power of ponytail and manifestation can do in the law.
We looked at the actual S40 exhibit. It did contain a portion of the detective's report, separate and apart from the charts. We don't have any objection if it's just the charts.
Okay. I agree, there's no issues with the charts, they should come in. But I'll just ask you to redact a portion of the actual report. Obviously, she testified to her report, so that's fair game for summation.
And then S42.
Any issue with that?
Well, I mean, I think that this, we just had a question about the, so, in the state, you know, they can, I don't know if this is their perspective on it or not, but, for example, as far as S44 and 45, the annual policy statements, like, we don't have any problem with documents like that coming in. They were testified to, they're fairly straightforward, they show the policy is active in those years, they show that where the records are going, they show who the insured is, right? So we don't have any issue with that, but the whole life policy of Keith Caneiro, that 19-page document, I don't know if the entirety of that was really the subject of the exam.
There's a lot of areas that were referred to both on direct and cross.
There were. And
should we give it to him for full context, so it's understandable, or what are you proposing?
Well, I certainly...
Judge, if you wait for him to come up with a logical and cogent reason or argument, we're still going to be waiting. He has yet to make one in 15 damn days of testimony. Don't do it to yourself, Judge Ken. You're already feeling sick.
I certainly don't have an issue if it is, you know, I'm not saying that anything that was discussed obviously can be brought up on summation, during summation.
Yeah.
And I would just say this, I guess our stronger...
Jesus jumping Jehoshaphat. Could you wander the Narnian fuck to where you're going? Could you Carmen Sandiego to a point? Giblets. You've been up there for 30 seconds and I'm still waiting for your brain to come up with a question.
Our stronger... So you accept we have an objection here. Our stronger objection is really S43. So, I guess what we could say...
Can we just reserve, Judge, and talk about it? Can we meet and confer? Because this was in our category.
Absolutely no, Tweedledum and Tweedledummer. Look, 0 plus 0 is still 0. You do understand if you multiply the one brain cell that both of you share, it's still 1. You are not the Wonder Twins of law. You are the cautionary tale of exposure to radiation.
Story of like we're unsure.
42 and 43?
Yeah.
Yes.
But you're okay with 44 and 45?
Yeah.
All right. So 44 and 45 are good to go. 42 and 43, why don't you take a look at, Ms. Wallace, you can let me know also, because I definitely recall there was a lot of areas that were being referred to back and forth. So there may be something that you guys can agree to as to the areas that were testified to, because you read them into the record, so just let me know.
I think we're at S44 again.
Well, 44 and 45 were good. There's no issue, but Mr. Murray said there was no issue there.
S46.
Okay, no objection there.
S47?
No objection.
S48? No objection.
Thank you,
S49?
Tammy, and I hope you have
S50?
a better weekend.
S51? No objection. S52? No objection. S53? No objection. S62?
I need to go back for a second. The S52. I'm gonna go to the trusted paralegals over in the corner. Are we sure that
Oh, I'm sorry.
we didn't, I don't think that was shown.
Okay, then, that was highlighted, I inadvertently then read it. If it wasn't shown, then.
Okay, so then 52 is not going in. Okay. I'll look back through my notes and see if I find it. But I'm sure that they have it.
So the counselors in the front table are the defense. The table in the back with the woman with the kind of poofier black hair with volume, they are the state. And the one woman with the headband and the woman with the glasses are their legals that have been in charge of getting all the document exhibits, all of the photos and everything else, the videos, and the actual physical evidence, keeping it in order, making sure they have the correct number. So they really have been the MVPs with the amount of evidence that was put in and the kind of subsections of evidence for at least some of the paper documents and photos. They've done a really good job of making sure the state's on top of it and has everything they need pulled.
I'm not seeing it, so we'll just take another look. Both sides will take a look.
It's in the Canada Life payment history, which was an exhibit that is going to be in evidence.
Oh, I do have it. On January 13th, it was marked. So we're okay. January 13th. So it's Tuesday, so that'll be in evidence. 52 is okay.
We have S53?
I think there was no objection to that already. Am I correct, Ms. Messala?
We don't believe so. We think that was the history of the invoices on policy.
Yeah, things I trust more than you two thinking together. Condoms made from unicorn. Let's see. Anything made by Bill Gates at this point? I don't know. Let's see. TikTok.
That's exactly what it is. Yeah.
The Leering Center.
So no issue there, right?
No objection. No.
Okay. Next.
S61, just A and D, which would be the photos of the defendant's phone from Detective Nicolaisi's report, and then photos of the Wise cameras from his report.
Yeah.
No objection.
Okay.
S62.
So we do have an objection to S62 through S65. These are the text messages or these are the text messages that Detective Miglorisi read into the record. They were shown on the screen and then
They were shown on the screen, Kim K. So I'm going to need you to go back and remember. It's going to be hard, but let me help you. The judge said that anything that's already been admitted and you didn't object at the time is going to stay in. Now, how about you try to keep up with the rest of the class? Have you talked to your doctor about Adderall?
indicate like what each message stated. The problem is if the court may recall, that like there's the messages themselves are not dated or timestamped, and the state had put, I guess, printed each message individually on a page and stacked it.
What the hell is the state attorney doing? Is the state attorney having a seizure? And I thank you so much, Trick Ripple. Genuinely, wow. Thanks for making this awful trial watchable. You're welcome. I am glad that they did have a day off yesterday, because I will admit that I was in a bad headspace and would have been much more cruel to this evolutionarily, like, the fact that these two can upright and don't forget to breathe is just astonishing to me. Thank you so much. I really want to study them like Jane Goodall. Because it is like a marvel that two incompetent people got this far. Like, do you understand the series of failures in the system that accounted for these two graduating, passing the bar, then getting jobs where they represent people against the government? Routinely?
Put, I guess, printed each message individually on a page and stacked it together. We have concerns that it's not like a normal extraction report where it's organized and you can follow along. So we have concerns that if it's in the hands of the jury, it could easily get like disorganized, and there's no.
Let me solve this equation for you, sweetheart. The jury is not functionally retarded, so I think they'll be okay.
Way to put it back together, and also I think that the testimony was sufficient, and I think if they wanted to know, if they had any concerns about it, they could also always either recall the testimony or ask for a readback. I have concerns about the formatting of those specific messages. It's just like a blank piece of paper with words on it. It doesn't say who it's from. It doesn't say.
She legitimately said it's like a piece of paper with words on it. Kim K, don't ever change. I keep going until they repeal the 19th. You keep aiming for the sky. Oh my God, what the hell is this? Daggone boob. No, in theory, she has been working as a public defender. Am I still muted, or I it is rare that I am speechless encountering stupidity of this magnitude, but I've said it before and I'll say it again. I honestly feel like Daryl Brooks could have done a better defense.
Who it's to. It doesn't say, or maybe it doesn't have the date or the time. It's not like in a pre-organized fashion.
Can I see those on the screen?
Please let there be a timestamp. Let there be a timestamp clearly shown on
Some of
them.
them might have had, it was 2 maybe, but not all of them, I think. And then the other issue, Judge, is we would also just maintain that objection to the first couple messages that dealt with divorce and not knowing where he was going to live. that was in April of 2018, not November. So, you know, we would say that it's irrelevant, or object to relevance and prejudicial.
Okay, so this first one was from Keith, and it was testified to here that this is Keith forwarding to Corey.
Right, it doesn't say that though on this.
There was testimony.
Yeah, there was testimony that said who it was to. Okay, let me see the next one. Same thing, and it says from Keith Caneiro. It was testified to that it was to Corey Caneiro. Next. Same thing, it says from Keith Caneiro, and it was testified to Corey. Same thing for the next one, that's the fourth page. And the same thing with the last one from Keith, that was testified to Corey. So that's
I'm so
62.
sorry.
So these are the
Yikes.
text messages.
So again, I am not a doctorologist, but you can alternate, and it's going to sound terrible, but take it from someone who used to assist with physical therapy. Ice for any swelling, cryotherapy to reduce swelling and kind of reduce that inflammation. And then, you know, listen to your doctors and listen to your body. Don't try to do too much too soon.
I think these are emails.
These are, they were in that the Google Hangouts section, so they're a mixture, I think, of emails and texts. And I would just note there's 4 batches.
We'll just call them messages. Yeah. Sorry.
That's okay, there's 4 batches of them, and we put on the record each time he would testify to a batch. It was April 11th, September 13th, September 17th, and then the final ones are from 11/5/18. And Judge, I would just note they all do say who they're from.
Right.
Yeah.
Okay. Let me see 63. One minute. So the first one just says, did you talk to the Terminex people? And then the next one says, was testified that that's Paul's phone number. Yes, they're not budging. So your position with this, number one, even though it's documented, Ms. Messalone, even though that it's documented on the exhibit list, it's not noted anywhere on the exhibit as to the date when this happened, even though that I'm assuming the extraction report says that, but it's not attached to this. Is that a part of the argument?
There is no extraction report that is associated with these messages. They're not taken from a cell phone, they're taken from the Google Cloud. So that's exactly the issue, is if they were associated with an extraction report, I would feel more comfortable with the jurors having organized information. If they
This man is Danny Glover level Lethal Weapon 4. Why the hell am I still doing this? And why is Chris Rock in my movie? Done with its defense. He is so done. He's like, I am 1 day to retirement. I'm going to get on my boat. And this defense is like the explosive on the toilet.
were to drop the messages on the floor, they can't, there's no way to put them back together. They're not dated, they're not time-stamped. I think that it would be prejudicial to have them like handling this type of uninformed information. I think they heard
Uninformed information. Ma'am, I'm not sure if you're aware, but as a lawyer, you're supposed to sort of be a wordsmith, or at least a persnickety and pedantic type person, because words actually mean something. In a contract, there can be a world of difference between and or. So you are supposed to be anal retentive to the nth degree about language, what words mean, and their usages. I I am if this is an indictment on the Federal Department of Education, I don't know. Also, why is it that Ian Crossland is cosplaying as a lawyer? I feel like he's every time he stands up, I feel like he's going to talk to me about graphene.
The evidence, and I also think it's, pretty.
When she's muted.
These messages are subject to the to the pre-trial litigation motion. So I think that there is an aspect that these are a certain level of prejudicial, perhaps the relevant or was outweighed the prejudicial value, or which is why the court ruled it. And it was admitted at trial. It was read out loud.
I love how Lisa Cuddy from House has decided to sit down until this. Wait, I have a banner for this. I really do. And I rarely get to use it. To this twat wobble babbling, thinking she's making coherent sounds. This is why aliens won't give us their advanced technology.
The jury, I think it was a...
I got you. I heard you. I was just asking a specific question. All right, I'm gonna reserve. I'm gonna look at these.
Can I just supplement too?
Yeah, of course.
There is an index that was provided. I understand that the argument is that the jury doesn't have them, but there is an index where it has all of the dates listed. The defense sat with us over the summer time, and Detective McLeary downloaded this onto their computer. They were able to view it. So there are dates. It's not that there aren't. It's just, I understand the argument that there's not necessarily dates on the page, but they were testified to.
No, I get it. The issue is that it's been testified to for these dates, but
save us headband, because this lawyer looks like he's about ready to stand up and do a falling down Michael Douglas.
there's nothing from, if they go back and just take the document, there's nothing that puts the September 13th date on it, other than the testimony. So let me just think about it. But I understand the objections, and I will render that decision on Monday.
Okay.
So that's 62 to 65.
66 would be next, A and B.
No objection.
S69.
No objection.
S70. S74, it would be A through D, and then there's a D.1.
No objection.
All right, so it was 69, sorry, you guys went a little quick. 70, you said?
Yes.
And then 74?
Yes, and that would be A through D, and then on 74, there's also the D.1.
Right, and there's no objection to that one. Okay, next.
S76, A through D.
No objection.
Okay. Then?
S78,
No objection.
S93,
No objection.
Okay.
S94,
No objection.
S96, that would be B.
We don't have an objection to B. What we wanted to do was, I'm not sure if maybe the entirety of both clips should be admitted, and for context, I'm assuming they were both played.
I don't think we would think chorus is.
No, one of the calls didn't play. They said 911 was the emergency and nothing. We didn't play.
Okay, no objection.
All right, so it's just 96B,
Yes.
correct?
Yes.
Okay.
S99,
No objection.
S101,
No objection.
and S102 and 102.1.
No objection.
S138,
Judge, we wanted to take a look at that more. We're uncertain about that. If we could just reserve on that for the moment.
You want to put in the evidence property receipt?
I think, I think it was just for purposes of chain of custody, a document, but.
Can I see 138? I think I can answer this. Ms. Massalone or Mr. Murray, is there an issue that you are going to argue as it relates to contamination of the evidence of those 4 items?
No.
No. Okay, so if the answer to that is no, then I'm not going to allow it in. It's not necessary.
Okay.
If there was an issue with it on another evidence property receipt, then I would consider it for them. But if they're not, I'm not going to put it in for any other reason. Okay?
Sure. S-150.
It can be talked about in your summation, but it just can't. All right?
S-155.
No.
S-156.
No objection.
S-157.
No objection.
S-158.
No objection.
159.
No objection.
160.
No objection.
161.
No objection.
162.
No objection.
163.
No objection.
164.
No objection.
165.
No objection.
166.
No objection.
168.
No objection.
169.
No objection.
170.
No objection.
171.
No objection.
172.
No objection.
173.
No objection.
74.
That we do have an objection to based on relevance. And same with 75 as well.
Go ahead, Ms. Wallace.
Thank you, Judge. I would just note these were shown to the jury. The relevance of the savings bonds, I mean, I think it's something that he had, and what the state's position is his go bag, essentially, along with his passport and some of the other items that were listed in there. S-175, the mail that identifies him as being his backpack, the financial documents in there, et cetera. I think that those are relevant as well.
I understand that the objection by the
It's pretty relevant that Paul had a go bag in the one car he decided to save from his house fire that had his passport, savings bonds in the name of his daughter, his side piece's credit card with her name, and a bunch of cash. And the barrel of the, force multiplier allegedly by ballistics used in the quadruple homicide. Yeah, it's kind of relevant, Kim K.
defense. I do find these to be relevant, and I also find under the circumstances that under a 403 analysis, I do find that the probative value outweighs any prejudicial effect. The theory of the state in this case is that the defendant, after he allegedly committed these offenses, that he was going to take off and he was going to need money to get out of here. We also included all of the information, all the items that were in this bag, to include savings bonds and to show identification of the bag. 175, I do find to be relevant. Again, under 403, I do find that the probative value outweighs any prejudicial effect. Even if there is some prejudice, it's not enough to overcome it. So I'm going to allow in 174 and 175.
Just so, as far as identifying the bag, 172 with his bank card and things of that nature, his passport, obviously that makes sense. The concern with the
Kim K, he said no, shut the hell up, sit the hell down. I know you didn't hear it from your parents, but he's the judge and he can say it to you. You don't get to negotiate again. He said, first of all, you didn't object to these when they were shown to the jury, when the state said, I'm going to look at these. If you have any objections, you're like, no. So you don't get to bitch now that they're in.
is also like the hearsay of the mail. I don't even know.
Like
I don't know
hearsay.
what mail this is. I have no idea who it's from, who it's to.
When the state's lawyers, seasoned lawyers, look at each other like, what the fuck did she just say? She's like the relevance or something. It was like hearsay. You know, at least Daryl Brooks got some of his hearsay objections right. Again, the fact that I'm defending Daryl Brooks as a keen interpreter of law.
I don't know what mail this is. I have no idea who it's from, who it's to. I don't know. Is it open? Is it like what's the mail? Is that why does that?
It's in a bag that's actually it's secured and fastened, so I don't expect anyone to be going through the mail or manipulating a piece. But go ahead.
No, it's just for the idea that they had all this stuff in the bag. We're not going to go and rip out. They're not going to be opening.
And I'm going to tell them that they can't do that, Ms. Massalone. So I understand your objection. It's definitely noted. But
No, Judge Kent, stop encouraging these ridiculous arguments. Stop telling her she has a point. But what does the mail even mean? Like, can't people to use only emails and DMs now? Like, who uses stamps?
But I disagree for this one.
Next one would be S-176. S-177. S-178.
So I think
Facts not in evidence. Facts not in evidence that you think. No, you don't. Not according to this trial.
if we could reserve, I think one of our objections is just, a lot of the firearms were shown to the jury. I understand the court made a ruling with respect to the weapons cache and how it's relevant, but any firearm that wasn't used or alleged to be used in this case, I don't know if that might confuse the issues, if we're admitting all of these guns into evidence, and firearm. So it was something that Mr. Murray and I wanted to confer about further, because we were just, so maybe that's something we can reserve on.
Tell me what 178 is again? I'm reading it, but just remind me what it was.
So, Judge, what it is that the gun was found in a case. It's a lock case under the defendant's wife's bed. It's a black case.
Oh, the one, we saw a picture of it.
Everything was kept in the case except for the gun, because the gun was submitted to the lab. The gun is actually it's in a gun box. It's one of the gun boxes that was shown to Lieutenant Catalona. And this case has everything else. It's got a knife. It's got a box of 9mm cartridges.
Tell me how this one is relevant underneath the bed, that it would be necessary for the jury to have it.
Well, I mean, he's got guns in that bedroom. He's got guns in the bedroom that's his own.
I'm not disagreeing. He didn't have guns all over his house. What I'm saying is, I'm asking you just so the record is clear. Why?
Yeah, Judge, obviously he's got access to guns that are in more than one place in this house. One's in a gun locker. The gun safe didn't have any guns in it. He's got one in the bedroom, in his bedroom in the drawer with the laser sight in it. And then he's got this one underneath his wife's bed. I mean, obviously it's been testified to. It's been ruled admissible by the court previously. So I'm not sure I understand the objection.
Okay. All right. I'll give Ms. Massalone the weekend to take a look at it. If there's something she wants to submit on this particular one. I did rule on this as a pretrial issue, that I was going to allow this to come in for this limited purpose, which is located in the jury charge. But we can give Ms. Massalone the weekend to take a look at it.
It'll take her all weekend.
S-179, that was actually the gun that was in that case, so I don't know if it's the same issue that Mr. Decker just talked about. It was
The actual gun?
Yes.
There's no objection to that, is there? Or is there objection to that one too?
The actual gun that belongs in the case, or?
The gun was found in...
My God, how are you a lawyer? How do you breathe? How do you remember? Like, do you just tell yourself to breathe in, breathe out? What the hell is going on here? I am so confused.
The case. The only reason it's not in the case now
You sent it out to the lab, right?
Right, so it's not the gun, like the gun that's alleged to have been used.
Correct.
So I think our
The gun, or you could say the alleged homicide weapon, like a functional lawyer would.
Our objection is really just, again, the purpose of the weapon cache, I think, has been sufficiently established, and the jury had the opportunity to not only hear the testimony about all the weapons in and around Mr. Caneiro's home, which obviously it's out there, we're not, you know, it is what it is, and on top of that, they got to actually see numerous weapons from the witness stand. So the objection is really just as to the prejudicial nature of them having the physical guns. I mean, it's one thing to hear testimony, it's another thing to hear facts.
State Attorney, we would like to welcome you to the Petty Express. You have earned the Order of Smartass level 1 for having to deal with this intellectually infantile ridiculousness for months and months, if not years.
Got to actually see numerous weapons from the witness stand. So the objection is really just as to the prejudicial nature of them having the physical guns. I mean, it's one thing to hear testimony.
State Attorney, I get it. Look, I do not recommend binge drinking. I don't think it's a good idea. But if you happen to drink Jack Daniels with a silly straw this weekend, I'll at least understand it.
It's another thing to hear facts and to see them. It's another thing to have access. Like, if they wanted to see the guns, they can just, you know, see them all. I mean, it seems...
Well, they actually can't see any of them because none of them are allowed back in the room. They're just in evidence, so to speak, but they will never leave the state's possession unless for some reason they wanted to see it. If they wanted to see the cache of guns, they would have to come out here. We would have to all be a part of it, including Mr. Caneiro. And I would, if they did ask that, I'm telling everybody straight, is that I would remind them of what they could use that for and what they couldn't use it for. So it's really more of like, it's an exercise, and we're saying that it's an evidence, but it's really not going in there for them to have any.
Of course, Judge. I obviously understand that, but that's what I meant. I meant, like, if they wanted to see the guns, they could see them, right? And why do they need to see them again? If I don't think that I think it would be prejudicial for the jury to have, when I say access to them, I don't mean that they're stacked in there with them. I mean, like, if they wanted to see them again, I think the point of the weapon cache has been established. I think the means and opportunity that the state wanted to establish has been established, and just the idea of the jury being able to say, we want to see those guns again, we want to see all of them, we want to look at them, we want to examine them or see them in the courtroom. You know, that's, at that point, I think we're going astray of what, you know, the evidence in this, what the relevant evidence in this case truly is.
Okay. But is this something that you wanted to reserve on, or do you want me to rule right now?
If Your Honor wants to rule now, that's fine. I mean, that's our position.
Okay, and I respect your position. Under the circumstances, because we're giving that limiting instruction, I have, while I understand the argument, I respect the argument by the defense, I don't have the same concerns. The reason why that I would find that this to be relevant.
Hey, Kim K, as a mom of 6 children, I caught that fucking eye roll, and I'm gonna need you to slow your roll. You have already shown weaponized incompetence to the nth degree. Judge Kent is at least giving you... He's being extremely kind in a bless your heart, your slow way with your ridiculous claims. But I'm going to need you not to roll your eyes again, because I will go full Medea on you.
I don't have the same concerns. The reason why that I would find that this to be relevant is if for some reason the jury is trying to understand the defendant's ability to understand how to use guns, even though there's testimony about it, if there was something about some of the other weapons that to show more familiarity for one of the jurors, I have no problem with them being able to see them. They're not going to be allowed to touch them or anything else, and it would be, like I said, it would be an open court. So I'm going to allow S-179. I will stay reserved, though, on 178, on whether that's necessary or not. But for 179, I do not have a problem with it based upon what I've said in the previous ruling and what I said here today. And just so that it's clear, on this final exhibit list, that was shown on January 22nd also. Okay. That's okay. It's okay. Next one.
S-180. No objection. S-181.
So anything that was like another firearm is just the same objection. So.
And they're all noted for the record, and my reason is the same for each one of those. So, but I get your objection, and it is noted for any firearm other than the alleged firearm used in this case. There will be a standing objection for the defense. I respect that. I'm overruling that objection. I'm going to allow them. Go ahead.
S-182. No. No objection. S-183. So just to clarify, I mean, so, sorry. I guess like one.
182 doesn't need to go in.
180.
Judge, I'm sorry, just for purpose of clarification, we could leave S-182 out, that's just a box. S-183 is the actual target. That's my fault for not identifying that.
Okay, so it's just 183 you're looking for.
Yes, I think that's really the evidence.
Are we on 183?
Yeah.
Okay, no objection.
Okay, next.
S-184, no objection. S-185, no objection. S-186, no objection. S-187. 187, 188 are just the same.
Same objection, and noted for the record, but they will be in evidence. Go ahead.
S-189. 189 through. Okay, so just to speed it up, 189 through 192, same objection.
All right, they'll all be in evidence.
S-193. S-193 is the gun, so that's the alleged gun. No objection to that.
Okay.
S-194. No objection. S-195. No objection. S-196. No objection. 214. No objection. S-222. Same objection, small plastic bin with 6 magazines and 11 unfinished blowers. Same objection, just.
Tell me about this one, Ms. Wallace or Mr. Becker.
No,
Judge, I
I
believe
think
I have to
it's,
look at it, but I don't even know that we even opened this up.
I think it's the portraits of all judges past, the ghost of law past, that really give it kind of a Hogwarts feel. I feel like all these judges are collectively, oh my God, I need to edit that. Can you imagine if we just had the judges in the background rolling their eyes during the defense's closing? I will work on that this weekend. But can you imagine one of the judges be like, God dang it, Dumbledore at least got respect.
I obviously, as the court can see and as the court knows, if you go forward and back, there was a lot of items that I chose not to actually identify and not to actually display, including the rifles and the Uzis and the, thousands of ammunition. I used the one as a sample. I think this was another one that was just a representative example, but I can look at that in our vault downstairs just to
Take a look at it. Let us know if that's an issue. If there is an issue, if you do still want to move it, just let the defense know, and then we can argue that. So I'm going to reserve on that one for now. Next.
S-225. So S-225 and S-226, we had an objection to relevance and prejudicial. It's the bulletproof vest, I believe, was shown to the jury, but it's just there's no relevance here. It's not alleged to have been used. It's just in the basement, something that was found. And similarly, the bin with old spare cell phones. There's no relevance. I don't know what the relevance is. I
hear you.
Judge, the relevance on 226 is the old phones. There was discussion about how the defendant left his phone home, and so the FLIR, only works in a phone. But there are these spare phones that were found.
There's no evidence to support that they were actually used. Is there? That these cell phones were actually used by the...
Not specifically, but I mean, that was an argument that his phone was home. There are all these other spare phones.
Okay. I'm not going to allow either one of those in. That you guys can argue that, but I don't find that they need the physical items of the vest and or the cell phone, so I'm not going to allow them physically into evidence.
The next one, Judge, is S-230.
No objection.
And then S-231, it would be A through E.
No objection.
S-232.
No objection.
Then S-233, 234, 235, 236, 237, 238, 239, 240, and 241, 242,
No objection.
and I think we showed 243, so not 243. The next one is S-253.
No, are you doing 244?
254 we have? I'm sorry, Judge.
Did you say 244?
We marked it on our thing.
I don't have 244 as being shown.
I got the next one, I'm sorry, not 253, it would be S256.
No objection.
Okay.
S261, and there's a 261.1.
No objection.
S262, and there's also a 262.1.
No objection.
S263, all of the A through, it looks like M, and then 263, B through M.
No objection.
So all of that is in. Okay.
S264,
No.
S270 and 270.1.
No objection.
S271A through F, and then 271A.1 and 271C.1.
No objection.
Dreaming of a flask. That wasn't me. Even court TV is like, please God, make it stop. Please God, be merciful.
S391. S392, it would be A, E, and H for the ones that were plead.
No objection.
So just those three.
Yes, those are the ones plead. Next one would be S405,
No objection.
407,
No objection.
S418,
No objection.
419,
No objection.
S437, thank you, 467,
No objection.
S474,
We weren't sure what that is. Is that?
that was the timeline Judge said. It was a defense exhibit, and then we wrote on it as well.
Oh, yeah.
Not great memory.
I will say that I have slightly edited for Pocahontas here my rendition of paint with all the... So she needs to paint with all the colors of bullshit. You can have no case and still you can argue like a shill when you paint with all the colors of bullshit. You can attempt to look like you're really a law officer. Look, Pocahontas, the legal defense musical, is going to be coming. I'm working on it. It's in development. I am talking to Andrew Lloyd Webber. If he's still alive, which he might be dead, now that I think about it. So
Got a little crazy.
You guys are having a party with that exhibit.
No objection.
Okay.
No, Kim K and Tristan Esquire, you know, the third, you guys ended up looking worse than... You guys ended up looking so incredibly dumb with that timeline. You shouldn't be smirking and laughing. In fact, the fact that you are proves the Dunning-Kruger effect more than anything else has effectively proved the Dunning-Kruger effect since the start of the internet. You are too stupid to realize how stupid that looked. Oh my God, you two, again, you looked...
I mean, S477.
Jesus, Mary and Joseph, what is this defense? We looked really, really stupid. Yes, we did. Are we watching the defense as done by Lionel Hutz and Troy McClure?
It was the DNA worksheet with the reference samples. I don't know. I mean,
mean, I know we're having expert testimony coming too, so I don't know what that's going to be using.
477?
Yes.
Can you put that on the screen, 477?
Judge, we didn't have an objection to that. I guess if we're not putting in reports though, we probably wouldn't need it from DNA.
As it relates to some of this stuff, if something becomes relevant as a result of the expert on Monday, you can let me know.
Sure.
But I want to stay consistent that reports are not coming in.
Oh my God, they found an expert. Is Judson mother effing legend with a paint can Welcher coming back to the New England area to work on subverting justice again? Are we getting the rematch of Logic and Paint? I am intrigued.
It's just the testimony as it relates to that. But if that becomes relevant, you can let me know.
Okay. We don't have, so there were a few exhibits that we had that were marked up.
Right.
The state did not have an objection to. It was like an allele table.
Right. I don't have a problem with those. I know what you're talking about.
And the two deconvolution reports. So I don't know if if the state had something similar, we wouldn't have an objection. We just had an objection to each and every DNA report that they originally, I think, were.
All right, let's do the, I know you want to argue the other part for the D exhibits. I don't want to do that right now. But as it relates to, for purposes of what you did on cross, as you highlighted that the results page, I don't have a problem with that because I think that would be demonstrative and helpful to the jury, however they want to use that. So that I would make as an exception to the ultimate reports. But I'm not sure about the deconvolution report. We can talk about that in a minute. But Ms. Wallace, you're looking like I'm saying something wrong.
No, Judge, it wasn't what I was thinking about. The next
Okay.
exhibit on the list is an electropharogram, which I don't think that that's going to become
Well,
relevant.
then why don't we wait on that? Because I'm not going to rule on that until I hear from Reich. Right?
Understood.
Yeah, I think in general, Judge, though, the electropharograms and the wheel charts and things like that, we're not going to have an objection to that because we're going to be using so much of that, I imagine, during the
Oh my God, they're bringing a DNAologist to explain away the DNA that conclusively, again, I want you to understand, defense, that yes, Paul and Keith were brothers, so their DNA was close, but not identical. So they were able to detect Paul's DNA signature, Sophia's DNA signature, and Jesse's DNA signature. So yes, while they are all, closely related, it was not so hard that they couldn't pick out the individual identifying profiles. Oh my God, oh God, do you remember when they tried to explain DNA? Be prepared for their expert to know just as much as the lawyers.
If you guys all want it in on both sides, then I'll make an exception to the rule on this, or my rule, I should say, on this. If you guys want that, I'm okay. But I don't want you to assume though that if we allow something like this in, I'm not sure about the deconvolution report because I do remember that from the prior hearing. Remember a lot of testimony about it, so I have to take a look at that again. But if you don't have objection to these items and for you to use what you've already used, I have no problem with that.
Yeah, I think we kind of anticipated that this was going to be something that was in front of the jury, and we don't have an objection on specifically talking about 478, 479, 480. We don't have an objection.
478, 479, and 480, you have no issue with it?
No.
Just I think we should take a look at this stuff because I think what we're doing here is we're putting in potentially deconvolution reports just because someone put a circle around it, but we're not giving them DNA results. So the idea that it's just in a vacuum, I think we have to look at what is relevant because obviously no one's going to remember 460 septillion versus 4.1 octillion.
They're not?
I doubt they are. I think the idea is obviously there's certain pieces of evidence that are, obviously relevant and probative. But I think we'd have to look at this because, I looked at Ms. Mastalone's stuff earlier, thinking that maybe they were gonna get certain things. Now, obviously, that voting table, we obviously have no issue with it, if we wanted to put it in two, and we can do that without putting in the whole report, but I think there should be at least some sort of summary of stuff like that.
All right, we're going to reserve on 476, 477, 478, 479, and we can come back, and 480, we can come back to it.
We're not trying to, we can also talk it out and see if we're on the same page with what the jury should have. Like, we're not trying to
respect
suggest that our stuff should be in and their stuff shouldn't.
I respect that.
The rest up to, looks like up to 493 were either the DNA lab reports or there was one other DNA lab reports. So, again, lump those in with the discussions that we're going to have.
Yeah, we'll hold off on the DNA stuff until after the defense is concluded. And then, and out of fairness, I should say this to both sides, that if you don't move something right now, if something becomes relevant after today, obviously I'll revisit it. So I don't want you to think you're precluded in any way. I would never do that. So let's come back to the DNA.
That takes us only up to 501 is the only non-DNA one that's left.
And that was from today. That was the photo of Mr. Caneiro and his daughter?
Yes.
So that we would object to because I thought the witness didn't lay the foundation. He said he didn't know when it was taken. He said he couldn't say. He said he couldn't remember if that's what Paul Caneiro looked like at the time of November 2018. I think based on our sidebar conversation, my understanding was that if the witness was able to lay the foundation and I guess connect the relevance to the case, then the court was going to allow it. But it was never published because I think the witness was able to do that.
Mr. Decker?
Well, obviously, Judge, we had to deal with what we had to deal with because part of that photo was also, I believe, her photos similar to that were also in the phone. Obviously, I know where I got the photo from, but I guess I'll defer to the court with respect to the testimony thus far in that regard.
So this is what I want to do. The one thing that I do want to, he did talk about how the age of the daughter, but I don't remember exactly the context. So we're going to go back, we're going to listen to that. You guys feel free to do it also. That would be the only thing that may give it context to around the time frame. But I agree with Ms. Mastalone. Otherwise, he was non-committal as to the time frame of when the photo was taken. So let me just look at the testimony on that. We'll make a final decision on that.
Just to put it into context, I think my recollection of the testimony is he said she was in her early 20s. At the time of November 2018, Katie Caneiro, the older daughter, was 26.
Okay. All right. So, and that, yeah, I think you're right. That's the exact words that he used. So I'll just take a look at it one last time and then I'll rule on that. Sure. All right, let's go to the defense exhibits. I'm working off of, on the defense exhibits, just the document that you gave me maybe a week or two ago.
It's okay.
Is that the document we're working off of?
No, we have a much more updated version, Judge.
So as far as actual exhibits, we did publish several during the DNA.
Before we get started, can you send by way of email right now?
Yes.
The updated exhibit list so I can print it out and have it in front of me?
Yes.
And send it to the state? We'll make a copy for the state so everybody has it.
There's a bathroom over there.
Okay, well, I think we are going to end there. I will be cutting the description of this case into its own separate video. And need I remind you that, again, if you think I am joking about this defense not reading the room, I would like to show you the witness they ended with. And when I say that this woman is the most off-putting, giggly, weird, squid pro quo, middle daughter broke my nose. So I understand, I do. Now, I want you to understand that this is the witness that they ended on, and that Wednesday they ended with the medical examiner breaking down after explaining how little Sophia passed away. This was the energy this woman came in, knowing that this is still, even if Paul is her friend, this is a quadruple homicide case.
You mentioned you met Susan in high school,
I did,
right?
yes.
And you were around how old at that time?
I was about 15 years old when I met Sue.
And what
Okay,
about
now, you guys, why in the hell is John Lithgow in a wig here? He, at first said that it looks like John Lithgow from Footloose, only he's wearing a wig for some reason. But JKD Buck pointed out that John Lithgow also played Trinity on Dexter, and this is Trinity with a wig. Now, you guys, I can't explain to you how giggly and smiley this woman was. Just, Paul was the greatest. Oh, here. This is where Paul pretends he has a soul while Trinity from Dexter with a wig talks.
agree or argue?
Yes, I mean, they were brothers, so of course they disagreed. Yes, they would disagree. They would discuss things, get their feelings out there. I actually admire their relationship because they could disagree and then go back to being best friends, going to lunch. So they would disagree. Usually it was Keith who would lose his temper. Paul was always the more even one, the fixer, keeping calm. And they would disagree, and then they would resolve it and move on and go out to lunch and just.
Now, if you haven't been following this trial, Keith Caneiro was shot in the small of his back, the top of his ass. The bullet went through his colon into his bladder, then ricocheted through his organs until it came out of his shoulder, out of his hand, and then he was shot an additional 4 times in the head. So let me see if I can get to the actual. I'm going to need to turn closed captions on because this is the actual, legitimately the worst. Where is it? Okay, this is, again, I want you to keep in mind that the jury left Wednesday with 2 medical examiners breaking down over the gruesomeness, the brutality of the attack on this family. And then this is what the defense decides to ask.
Agree or argue?
Yes, I mean, they were brothers, so of course they disagreed. Yes, they would disagree. They would discuss things, get their feelings out there. I actually admire their relationship because they could disagree and then go back to being best friends, going to lunch. So they would disagree. Usually it was Keith who would lose his temper. Paul was always the more even one, the fixer, keeping calm. And they would disagree, and then they would resolve it and move on and go out to lunch and just resume the relationship.
Why the hell are we listening to the grandma from Addams Family after she got a dye job? Again, this woman is the human personification of that crazy cat lady in The Simpsons. This is supposed to be a good witness.
Like nothing ever happened.
And what about Paul's relationship with Jesse and Sophia? What can you tell us about that?
Now, again, if you didn't catch my breakdown of Wednesday, the audacity to bring up this man's relationship with his niece and nephew. Anywho, you guys, I need to get off of this. I am going to change because I am sending you guys over to a fundraiser that Nick is doing for, oh crap, I have completely forgot the name. He is a content creator that Lauren Owens has decided, she of the Immaculate Oral Conception Squared, has decided to serve with a lawsuit. So we are going to try to help him deal with this ridiculousness. I just cannot for the life of me remember his name right now. Sorry, you guys. I will work on being a professional, but I am. Hey, Rob. Thank you, Squid Pro Quo. I'm like, there was a name and a guy. Look, y'all, I have had to deal with weaponized gamma level radiation stupid today. So I am going to take a break. I am going to doctor myself an adult beverage, and I'm going to send you over to Nick Streams early so I can just take a break from stupid for just a couple minutes, y'all. We are not missing much as far as whatever the defense is doing. So I'm going to send you there to get ready, get some snacks, get your optional adult beverage, and take care of yourself emotionally. Go play Sudoku or a crossword puzzle, just to make yourself feel smart again. Bye, you guys.